step one was, as we saw, the three steps that you told us. Just
Yes,
one second, I'll just go back to it.
Correct, Maharaj.
Notice of removal to the speaker,
Yes.
resolutions given to the governor, and the act of being sworn in as CM.
Correct.
There's one step earlier, probably one step which you can also add there, which was the governor's trust vote communication.
I'm grateful, Maharaj. I'm grateful.
Right. Now,
Fourth step.
suppose, notice of removal of the speaker, we are not really called upon to adjudicate upon the validity of the. क्या हो गया? तो क्या है भाई? You said 3 o'clock, so they can. Oh, नहीं, अभी time है. Ciao.
No. Except in Navam Rebia. Your Lordship, if your Lordship chooses to refer, would have that issue. Navam Rebia,
if we choose.
In the broad, no, I'm saying it arises. I'm not saying your Lordship may have to for this case. I'm saying that's the core issue.
Of course.
No, I'm saying, well, it's an issue.
The governor asked for a trust vote.
Yes.
Two ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government.
Pinpointing, picking out a person and saying.
Picking out a person, because
correct.
Even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. There was no valid material at all on the basis of those three circumstances.
That's a core question. And that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet, but perhaps didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to galat fehmiyan और भी बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं." उसने वो भी सुना जो मैंने कहा नहीं. Well, the governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 of the resolution itself there. So he's hearing things jo kaha nahi.
The resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta, not Bashir Bhadra.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very.
No. I'll be dealing with Bomai. That's the core question. Your Lordships is saved a lot of unnecessary exercise if your Lordship comes to that conclusion plus follows Bomai, which in any case is.
So then according to you, what? We reinstate the Uddhav Thackerey.
Straight away, let me first change my tack and go to Bomai.
But you resign, no?
No. I covered in my note directly. 5 reasons. Justice Shah asked me that one in the beginning. Your Lordship asked me that. I'll straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant. Completely.
But that's Ms. Dr.
No, I'll deal with it. So let me deal with it. So let me deal with that.
It's like the court being told that you reinstate a government which has.
No, it's
acknowledgement by you.
I hear your Lordship loud and clear.
Resign.
It's a question asked earlier, and it is actually a plausible looking thing, but it's actually irrelevant. I'll show that in a minute.
No, Mr. Kapil, how can, just hypothetically,
yes.
How can the court reinstate a chief minister who did not even face the floor of test?
Your Lordship is not reinstating anybody.
Then what will be the consequences?
Your Lordship is and should and does, and Bommai says it more graphically, restore status quo ante. That's the meaning of a.
But Ms. Dr. Singhvi, it would have been a logical thing to do. That's where we are, it would be a logical thing to do, provided you had lost the trust vote on the floor of the assembly.
Lordship may just flag that.
Because then clearly you have been ousted from power because of a trust vote which is set aside.
Correct. Duty bound to satisfy Lordship, and I believe that.
Right. Now our problem is look at the intellectual conundrum.
Yes.
That it's not that you have been ousted from power as a result of a trust vote which was wrongly summoned by the governor. You chose not to, for whatever reason, you didn't want to face the trust vote.
I faced that squarely. Allow me, I'll change my sequence and come to this first right now. May I, Malas? Because straight away your Lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law, your Lordships. If your Lordships comes to the conclusion of the other one. Give me just 5 minutes on this. May I end the first part, Malas? That is, Malas, this affirmative and negative code.
Yes, that you
with only one, with only...
Now, Dr. Singhvi, we are 17 minutes past or 18 minutes, closing on 18 minutes past 3 p.m.
Tuesday, Malas.
I think 3:30 we'll close now. I think we have seen everything now.
No, Malas, your Lordship, I am asking, 3:30, it's now, Malas, 3:20. I've done 1 out of my 7 points. Malas, this is a matter of some moment.
But Dr.
I am not
now
going
to conclude. I mean,
Malas,
you can't just go in.
Conclude, Malas, but it is a very useful, when your Lordship asks questions,
now your points are really alaps of your...
No, Malas, with respect.
You are in rejoinder council.
Malas, I have argued 1 out of 8 points. I would not otherwise take time. And Malas, your Lordships, it is not intended to stop your Lordships, Malas, querying, because your queries actually make us think.
All right, Dr. Singhvi, you are always very precise. You are always very precise. Now go into the next point.
Your Lordship's compliment is intended to render me speechless. Malas, I'm not going to be speechless.
No. No, it's not like that. Dr. Singhvi, there is too much. The point is, there is a lot of stuff that we have to reflect on now, and we just want you
to maybe your Lordship will just
a little
over 4 o'clock.
Summarize it for us so that we can have...
Let me speed along, and Malas, your Lordship may give me a few minutes after 4. See, I am very keen to finish, Malas. I'm not... Till now, I have not repeated a single point. I give your Lordship a new facet.
Now not interrupt you. Go ahead.
Yes. So, Malas, let me end this first point by saying, let me end the first point by asking myself a reverse question. What happens in my first point of affirmative and negative if your Lordships were to accept their interpretation? That's a good way of answering my Malas proposition. Namely, your Lordship will have nothing left in the 10th schedule. How does your Lordship operate both? The 4-step or the 3-step becomes the norm and will be followed in every case to defeat the 10th schedule. That's my first point. Second point on resignation. Now, Malas, your Lordship also has to deduct, Malas, 220 my learned friends for occupying your Lordships. And now, Malas, now the second point. Just look at this resignation trust vote a little carefully, Malas. I have 3 or 4 answers. It is irrelevant for the following reasons. Malas, just turn to paragraph.
Singhvi, the reason why we are wrapping you up, so to speak, is not because you have no case.
No, Malas.
I ask you to wrap up only because now the burden shifts on us to, as adjudicators, to apply our mind and step back and
so let me, Malas, now
decide.
Speed up. I think, Malas, oral things help, but to speed up, let me ask you to read paragraph 14 of my note, A7. Paragraph 14.
Just formulate it for us.
Yes, the formulation.
We've now got a...
When, Malas, now I'm answering the second head. I had 6, 7 heads. This is my second head. And it starts, Malas, this head starts at page 6. It starts at para 9, page 6. Resignation.
The act of resignation.
The act of resignation subsequently on 29 June would not defeat and would have no relevance to the reversal of the illegal action of the governor of 28/6. And in accordance with precedent, this honourable court should effectuate a real and meaningful remedy. Now, Malas, your Lordship recollects my A3 submissions, para A to N, which are repeated here. I argued, Malas, ibi jus, ibi remedium, fait accompli, status quo ante, all that. I'm finishing off in 1 para. I'm not arguing. I'm just reminding your Lordships. Now, skip all that and come to, Malas, para 14 for a minute. Does my Lord have para 14? Once the illegal act of the governor is allowed to be implemented, the result was a known and foregone conclusion. Factually, there was no need for the ex-CM to subject himself to it. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackerey resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act, the consequence of that is known to me. Now, just to save time, let me read it. The crux of the issue raised in the petition, where Lordship has got 14A, Malas, 14A, third line. The crux of the issue raised by the petitioner remains that the direction to hold the trust vote was an illegal act because the governor did so by recognizing a faction of 34 legislators. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, So prior is important. And pending in a court, a participation or absence of participation of ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, if one, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote, it would make no difference in law because the trust vote was merely the consequence of the illegal act of the governor, and the challenge would still relate to the governor's actions and not to the trust vote. D. It is therefore obvious in law, Malas, that the consequence of an illegal act, emphasis on consequence, cannot determine the legality of that act or validate it. Indeed, it could also be said that the petitioners, having challenged the core illegality at the base, namely the governor's actions, without any delay, did not even need to challenge the trust vote. I could have said it's nothing but a consequence. Similarly, if the individual illegal actions are broken up, and they are different petitions, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor inviting and administering oath, the participation or absence of the ex-CM has no relevance. Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para
So this is the second point. No, Dr.
This is the second point, but just one thing is left here. Para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law EBUs, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, Malas, in that. Kindly, Malas, do me the favor of treating it as having stated here. Now, Malas, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Malas, Karnataka and Meghalaya, is very important, is liable to be struck down, and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have been happened in the intervening period.